Contesting a will is more common than it has been. There are ways to contest it that are easier than others, but the first thing you need to do before you think about contesting a will is to have a good understanding of what the will actually says. Because if you're a beneficiary or someone who's going to take under the will, and you don't like what you got, maybe you got a third and your sister got 2/3, you got 2/3 of one asset and they got the really good stuff over there, sure you can fight. You better know what that will says, and frankly you need to know what the living trust says, because most well-drawn, lawyer-drafted wills and trusts will have something in the document called a no contest clause. If you decide to fight, you might find yourself disinherited like that, because the trust of the will says if anybody fights, they get cut out. So you can fight, but before you fight, you better need to know whether or not your fighting is going to get you disinherited. You can hire a lawyer. And lawyers are going to get paid one of two ways in this. They're going to get paid by the hour. If they get paid by the hour, they're going to look to you to pay them by the hour. It can be a very expensive process. Assume that you've got plenty of money, that's something you can handle. Most people don't have a lot of money. Most people don't have the kind of money it's going to take to do a will contest, and so they hire a lawyer on a contingency fee, which means a percentage of the estate. Lots of lawyers out there will accept a case if they think it's a good case and take a third of what you might receive because they're representing you. Maybe they'll take half. Depends on the lawyer, depends on the state, depends on the facts. But you can contest a will or a trust. Just make sure you understand what you're getting into before you get into it.